Right, ladies and gentlemen, welcome to today's Greater China Legal History Seminar. On behalf of the Faculty of Law of the Chinese University of Hong Kong, I would like to thank you for coming and joining. I have two good news. Today, again, we broke a record. We have 280 registrations. The second piece of good news, of course, is that we have an international speaker today here, Professor Douglas Arner, who will speak about the development of legal compliance. Professor Arner is Carey Holdings Professor in Law at the University of Hong Kong, and in fact, one of the leading experts in financial regulation. He has led major research initiatives and worked with practitioners and law firms. He has lectured all over the world, and we are glad to have him here today. Please welcome Professor Arner.
Thanks very much, Lutz, and thank you to Lutz, Stephen, Gina, and the entire team at Chinese University Faculty of Law for the invitation to be here today. When I was asked to speak on this topic, I definitely was not anticipating a room full of people. But I think the response, the turnout, highlights very much the overall trend and point that I'm going to make across the presentation today. And that is that particularly over the past 25 years, we have seen an absolute explosion in the numbers of in-house positions, but also of compliance positions. And this has been a global trend and one that Hong Kong has very much seen as well. Now, I'm going to focus in the context of the industry that I work in the most and know the best, which is financial services. But it also happens that financial services has been the industry that has probably had the greatest growth in the levels of compliance spending, levels of compliance staff, levels of compliance enforcement related activities. So, if we are looking at this topic, what I'm going to be talking about over the next 45 minutes is drawing on two big research projects that have actually been joint between Hong Kong U and Chinese U. The first, a major project funded by the Hong Kong Research Grants Council's theme-based research scheme on enhancing Hong Kong's future as a leading international financial center. And on that, at Chinese U, I worked very closely with David Donald, with Robin Huang, with Xi Chao, who's here today. And a second one on balancing the opportunities and risks of financial technology, looking at fintech regulation and policy, which once again, I'm working closely with David Donald here at Chinese U on. What am I going to talk about? The first is I want to talk about the evolution of compliance, particularly in the financial sector. And I think in order to understand the direction, and I think for many of you what is most interesting about what we're going to talk about today are the directions that we see the compliance function, the compliance industry, and compliance requirements moving into in the coming years. But in order to understand that, we need to look at the reasons why it has grown so much. And I think this is particularly important. I remember when I moved to London in the 1990s, going in to the Bank of England and trying to meet their in-house legal team. What did I realize? In 1995, the Bank of England had no in-house legal team. They hired their first lawyer from Freshfields in the second half of the 1990s. If I think of my own university, if I think of Hong Kong U, I remember coming in and being amazed, coming from a US and UK context, that there was no one dealing in the university with legal issues. We had a law faculty, and if the university needed legal advice, it would either hire outside counsel or ask the dean of the law faculty. That's crazy. And if we think of today, Hong Kong U, about 15 years ago, hired its first in-house lawyer. And certainly if I think of when I moved, or when I first came to Hong Kong in the late 1990s, meeting with people at large financial institutions and large corporates. Even an institution like HSBC at that time would have had a quite small in-house legal and compliance team. If you look at a global financial institution of any sort today, the question in many cases is, are there more compliance staff than frontline fee earners? And that's often a joke that is made, but in some institutions, it's actually true. And that is a trend that we've been seeing over a multi-decade period for a range of reasons. And so we'll turn from this evolutionary context to look at what financial sector compliance looks like today. In particular, picking up some of the bigger cutting-edge themes that we're seeing impacting the industry, and that leads us into the discussion about looking forward. And the big theme that I'm going to pick up in the context of looking forward is really about technology and the way that we are already seeing technology dramatically changing the compliance function, as well as the way that regulators themselves operate in an increasing range of jurisdictions, including this one. And eventually I'll get to a point where some of you may know that the SFC here in Hong Kong last year tendered for the building, the development of a US-style Edgar system. What is that about? That is about digital delivery of reporting requirements into a system which can be immediately subject to analytics by the regulator in terms of identifying potential risks or pursuing enforcement actions. And so this is a trend that has been a bit slower, as many other trends are in this context in Hong Kong, but I think is beginning to pick up speed. So I think if we're looking at the evolution of compliance, I think we can say that in the 1970s, 1980s, this was pretty limited. In particular, if we think of this period in Hong Kong, most financial institutions, most listed companies would have had a company secretary, and the company secretary and maybe that person's small administrative staff would have dealt with most of the sort of financial sector compliance issues. What were most of these? They were things around accounting issues and listing rules that largely historically would have fallen into this context. They likewise might or might not have had a legal advisor, a general counsel in the US context that played a role typically not at board level, but a much more supporting role in the context of dealing with legal issues as they arose. And it's really only in this period across the 1970s and into the early 1980s that even in the US, we begin to see significant growth in the role of general counsels in particular. And I think if we look across the 1990s and the 2000s, this is where we begin to see most of the growth pillars across compliance. We see the launch of corruption laws, both from the US as well as at the international level. We see the beginnings of a continued growth in AML, anti-money laundering issues. We see the beginnings of pursuit of taxation issues, particularly around tax havens, but this is one that continues to get. This is also the period where we begin seeing some of the biggest growth in financial regulation, and as a result, we see across this period financial institutions and large corporates everywhere building, in some cases, particularly outside of the US for the first time, often substantial in-house legal and compliance teams. But certainly in the 1990s and probably up until the 2008 global financial crisis, for many institutions, those functions, legal and compliance, would have been grouped together. They would have been grouped together into a single department. And I think what we can say for the 2010s, particularly after the 2008 crisis, and going forward, is that this is a period that has been dominated by an absolute explosion of regulation everywhere. And it's something that Thomson Reuters or Refinitiv, depending on which one you want to look at these days, tracks. The numbers of regulatory changes happening on a daily basis in jurisdictions they track around the world number on average in the hundreds. That is a lot of regulatory changes, and particularly for a cross-border institution, whether or not a financial institution, that is an increasingly complicated burden to deal with. We've also seen an explosion in enforcement actions. And a figure that is often highlighted is that in the financial services industry since 2008, financial institutions have paid over 300 billion US in enforcement penalties. The combination of regulatory changes, large penalties, have really driven an explosion in the size of compliance teams. More recently, and I think as we go forward, we're beginning to see a shift from the immediate 5-6 years post-crisis, where basically the goal of most large financial institutions was simply to throw bodies at compliance issues. In other words, hire as many people as you possibly could in order to deal with this explosion of regulatory requirements, and whenever the regulators came in to investigate potential issues, to be able to show that, yes, we have all of these people that are doing these things. Increasingly, we're beginning to look at this, particularly at a board level, from a much more strategic angle. How can we control some of these costs? How can we use some new technologies in the context of not only greater efficiencies, but also from the standpoint of strategic development of financial institutions? And I think if we're looking at what has been the drivers of this explosive growth in the size and scope of compliance and the compliance industry over the past 30 years or so, I would highlight 5. The US. The US, and one can think simply of corruption, of taxation, of AML, that the US, and in particular through application of extraterritoriality in the context of a number of specific laws, including the securities laws, has been one of the biggest drivers of compliance. But it has to be said that the reason this matters has been because of a process over the past 30 years or so of globalization, particularly of financial markets, and the influence of legal systems on cross-border operations. Now, the US is not alone in that context of extraterritoriality, and certainly in recent years, for many people working in the area of compliance, some of the biggest drivers have come not only from the US, but also from the EU. And in particular, I'm thinking of things like MiFID II, the Markets in Financial Instruments Directive, which came into force last year, or for pretty much every firm in the world, something called GDPR, the General Data Protection Regulation, which basically affects every business everywhere in the world, which is dealing with data from EU customers. So, the US, but not just the US. Extraterritoriality from the US, but also from an increasing range of other jurisdictions, particularly in the data context. All of this made most important by the context of globalization across the world that is still made up of hundreds of different individual legal jurisdictions, each with their own requirements. One, of course, has to add to this financial crises. Obviously, the 2008 crisis has been a huge driver, but if we think of financial regulation in Hong Kong in particular and its impact on the compliance industry, global financial crisis has been very important, but actually the 1987 market crash, the Hay-Davidson report, the creation of the SFC, the merger of HKX, and the subsequent creation of the Securities and Futures Ordinance has been one of the biggest drivers in compliance in anyone working in the securities industry. Likewise, the Asian financial crisis in the late 1990s drove a wave of regulation, particularly across Hong Kong. And finally, I've highlighted the G20, but the G20, I think, today is one of the most important drivers. Why? Because it is the most recent of a series of international efforts to come up with coordinated or, in some cases, harmonized approaches to regulation to try to deal with both some of the issues that arise as well as some of the challenges of operating on a cross-border basis. And we'll see that if we look at some of the recent G20 initiatives where we've seen some of the biggest impact on compliance, obviously financial regulation, but another one has been very much in the context of corruption, and a third in the context of taxation. We think of taxation, obviously the US has been a main driver. FATCA was a nightmare for many people around the world, but effectively FATCA has now been adopted at the G20 level in the context of the CRS, the Common Reporting Standard, of which Hong Kong is an actual member. So we see at the international level that members of different types will often drive a certain issue through adoption at the G20, at which point it begins to spread through countries around the world. So, if I was going to pick 4 pieces that have been particularly important, I would say securities and financial regulation. Most people would probably start with the FCPA, the Foreign Corrupt Practices Act from the US. But actually, if we look at the US securities laws, and in particular the continuing disclosure obligations under the 1934 Act, this, as companies from all over the world have increasingly listed in the United States, has had a huge impact. Certainly from the standpoint of US listed companies, much of that early drive in the context of the growth of in-house legal and compliance departments was driven in particular by securities laws. Bribery and corruption, a key feature, money laundering, and more recently terrorist financing, and tax issues. So if we look at bribery and corruption, I think that the FCPA we can see coming out in 1977, but importantly, that gets implemented or expanded globally beyond a simple US extraterritorial approach through the OECD Anti-Bribery Convention from 1997. So basically a 20-year period between the US's initial efforts at bilateral expansion to address corruption to the adoption at the OECD of an anti-bribery convention. Of course, in Hong Kong, actually an earlier start, the establishment of the ICAC anti-bribery laws in 1974. So this is something where actually Hong Kong has had a long position and involvement. Certainly if we look at the G20 post-2008, this has been an interesting one because there were real questions about how the G20, and in particular across developing versus developed country members, would treat bribery and corruption issues, and in particular concerns about the way that China might be willing or not willing to address this. But actually, as a result of Xi Jinping's anti-corruption drive, we've seen a remarkable level of support at the G20 from China in the context of internationalizing international corruption efforts. So this is one where I think increasingly there's not much disagreement about bribery and corruption being an important focus. There are questions about how to do that, but the end result, and we see continuing periodic actions, particularly from US regulators as well as European regulators, but also from Hong Kong regulators, enforcing these, which continues to drive spending and the development of ever more sophisticated compliance efforts. The second, and one that I'm going to spend a little bit of time on because it's one that for most of you working in the financial services compliance area, this is going to be one of the biggest concerns. AML and CFT, money laundering and terrorist financing. And once again, this started as largely a US initiative in the early 1980s, resulted in the creation of an informal international organization called the FATF, the Financial Action Task Force on Money Laundering. FATF created its original 40 recommendations. Those have been revised in 1996, in 2003, and again most recently in the wake of the global financial crisis. The FATF is an interesting model because it shows how we often see international efforts in enforcement work. It's a soft law organization. There's no AML treaty. There's no AML convention. Generally, there aren't even MOUs between regulators. This is a soft law agreement which is only effective as law when it is implemented into individual jurisdictions. So Hong Kong has been an FATF member since 1991 and has gone through a continual process, continuing straight up to today, of updating and continually changing to meet international standards laws on AML and terrorist financing. If we look at these, how do they work? Basically, historically, the FATF each year will come out with a blacklist of countries. Countries which are on that blacklist will basically then be subject to regulatory warnings issued by domestic regulators in the FATF member jurisdictions. So basically, anytime the FATF identifies a jurisdiction, not just countries, but a jurisdiction, as being not in full compliance with the FATF's recommendations on money laundering, individual FATF member jurisdictions, most importantly the United States and the EU, will release warnings to financial institutions licensed in their jurisdictions about doing business in that jurisdiction or with counterparties from that jurisdiction. So it's something that has become incredibly effective in getting jurisdictions to change their domestic laws to bring them into line with international standards. And today, there are very few jurisdictions which have not done so. Iran, late last year, completed a process of reforming its domestic laws on money laundering to bring them into line with the FATF recommendations. You basically have a few countries, North Korea, which is not yet in compliance, and a few others which are basically situations of state collapse, which have not been able to implement the recommendations. But pretty much the rest of the world has largely bought into this. We'll come back to a question about how effective they are later. But certainly in the aftermath of 2008 crisis, there has been once again an expansion in the context of AML. And I think this is an area where certainly in Hong Kong, we've seen a lot of this front line. Why? HSB Standard Chartered. HSBC and Standard Chartered both entered into $1 billion plus US dollar non-prosecution agreements with the US regulatory authorities over AML and also sanctions, and that's a different issue, violations. Those non-prosecution agreements required HSBC and Standard Chartered, as well as BNP and a range of others around the world, to implement comprehensive systems addressing money laundering issues across all of their global operations. And in effect, those institutions, as with many other institutions, now will have to, on more or less a T+2 basis, have to be able to provide information about the accounts of any of their customers anywhere on a worldwide basis. And this has been a big difference if you think of, in particular, HSBC, which historically has had a somewhat, I don't know if you'd call it balkanized, but country-specific separate structure. And the implementation of the AML settlement agreement very much required a much higher level of centralization, particularly in the context of account opening and monitoring of those accounts, as well as delivery of information about the users and holders of those accounts than we have seen before. So I think some of these large post-crisis settlements have been particularly evident in the context of AML and terrorist financing. But an issue that has definitely arisen in Hong Kong and globally is often labeled under the somewhat anodyne term of de-risking. What is de-risking? It basically says that many customers are not worth the effort of complying with the AML requirements, so you either get rid of them or you don't take them on in the first place. That's de-risking. Now, the problem from the standpoint of studies of de-risking is that typically those who have been most subjected to this are the ones who are either at the bottom in terms of income, formalization, etc., or they are startup companies. That startup companies particularly lack access. And so, as well as third, developing countries. And we'll come back to why developing countries. Now, as a result, not only in Hong Kong, but globally, there's an increasing discussion about de-risking. And it's a funny one because as each of these areas has become specialized, you get a specialized set of standards or a specialized law on corruption or AML. You will then get a regulator who specializes in AML or corruption issues or financial sector issues. You will then get within financial institutions and large corporates, staff or even departments. Most large financial institutions have a department that deals with AML. The result of that specialization is a silo-based approach. They're concerned with what they're concerned about, which is implementing the AML requirements. They're not concerned with the broader implications for the economic system or access to finance or development. And as a result, we've seen an interesting, somewhat conflict at the international level between the FATF and the Basel Committee in particular taking very conservative approaches, and the politicians and finance ministers of the G20 wanting to take a somewhat more liberal approach. And this is one area where the G20 has been effective in stepping in with its ability to direct some of these other standard-setting organizations to begin taking account of certain issues. We'll come back to the money laundering issue. Tax. I think this is one that is well familiar, and I think it's one that Hong Kong for a very long time took a very principled and appropriate view on. Hong Kong has historically a relatively simple, largely jurisdictionally based tax system, and basically the general view of Hong Kong throughout the past several decades has been that that means it's not really concerned with what goes on elsewhere. That has changed, I think, in recent years. We saw initially as a result of U.S. systems of global taxation of U.S. citizens and entities, a process of expanding pursuit of taxation. This centered on so-called tax havens and offshore jurisdictions in the 1980s, 1990s, 2000s. But probably it finally had its biggest impact in the context of AML issues and the reduction or change or alteration in banking secrecy laws in Switzerland and a range of other jurisdictions over the past 15 years. Building on that, and one that I mentioned earlier, FATCA is issued by the US in 2010, requiring reporting of account data on all US citizens and entities, regardless of where they may be, with a big stick penalty of preventing access by the financial institution to the US financial system in the event of non-compliance. And of course, in Hong Kong, this has been something that has been a big impact in many cases. Post-crisis, the G20 has picked this up in a way that it had never picked it up before. Why? After 2008, governments everywhere around the world have been very concerned with government spending and government revenue to pay for that government spending. And this has driven a much higher level of concern with tax leakage, tax that could have been paid as a result of accounts or assets or investments that are outside of the home jurisdiction. And as a result of that really consensus amongst G20 members, we've seen a very substantial post-crisis change in the international attitude towards transparency, but also in particular offshore accounts. We've seen a series of actions against UBS, HSBC, and others. More recently, we've seen the Panama Papers. And obviously, that's one that had a particular relevance in the context of Hong Kong, in that we happen to be the jurisdiction which had the single largest number of entities in many of those lists. And as I expected at the time, the release of those information, and particularly the fact of large numbers of politicians, government officials, and others from a wide range of countries being highlighted, has driven an international effort towards greater transparency, which eventually resulted in a common approach. And of course, Hong Kong in 2018 joined the Common Reporting Standard and is now sharing tax data on other OECD and G20 member citizens with accounts here, in addition to data about US citizens. And of course, from the standpoint of compliance, this has created a massive need in the context of spending and development. Securities regulation and accounting. I mentioned the 34 Act in particular. I think this really gets picked up with the international organizations, not only IOSCO, the International Organization of Securities Commissions from 1983, but the International Accounting Standards Board. And one of the drivers has been a process of harmonization of accounting standards, to the point where today in the world, generally speaking, you will find two systems of accounting that tend to dominate in most places. US GAAP in the US and international financial reporting standards that dominate pretty much everywhere else. Harmonization of accounting standards has led to harmonization of treatment of many things like bribery and corruption payments, tax payments, and the like, as well as increased transparency around the operations in particular of listed companies around the world. And this, I think, has had a major impact in compliance. I mentioned Hong Kong. Hong Kong 1987 crash results in the Hay-Davidson report and massive growth in securities compliance. 1987, and in particular, the pre-1987 crash period, the time of Wall Street, the first movie, of Ivan Boesky, of Michael Milken, this was a period that really triggered the beginning of international cooperation on enforcement of securities activities. Basically, as markets became more globalized, so did ability to manipulate or trade on those markets in an illegal manner. And as a result, regulators around the world have, over a period of decades, massively expanded the amount of cooperation, because in many cases today, you can't investigate a market manipulation or an insider dealing case without looking into other jurisdictions. One, of course, can't forget Enron and the related Sarbanes-Oxley Act, which had a dramatic increase initially just on US listed companies, but as David Donald and others have showed, have now largely been adopted in most similar jurisdictions all over the world, but with a consequent expansion of compliance and enforcement requirements. Finally, in the post-crisis period, if anything, the interlinkages on the security side continue to grow. Perhaps the best example of this, and one of the greatest focuses for securities regulators, 2010 flash crash, supposedly triggered by a UK day trader trading from computers in his parents' basement in a suburb of London. Now, what this highlights is the interlinkages, it highlights technologies, but it also highlights the essential aspect of cooperation. Banking and financial regulation. Really, most of banking regulation starts across the 1980s. Prior to that, most banking regulation was about interest rate controls, about expense controls. It was pretty primitive stuff. But the 1980s see the creation of Basel I in 1988, fit and proper standards in the 1987 UK Banking Act, as well as the UK Big Bang. And we begin to see some pretty dramatic changes. 1990s, a series of crises. Each crisis is followed by a regulatory response. BCCI with particular relevance in Hong Kong. Bearings, the Asian financial crisis, LTCM. Each crisis resulting in new regulatory reforms which have to be implemented and complied with. HKMA, created in 1993, Financial Stability Forum, created in 1999. Prior to the global financial crisis, Basel II, EU single market, the development of internal risk management systems like VAR exploding across the financial industry. All, of course, in some ways culminating in the 2008 crisis and an entirely new pattern of new regulations, not just from the crisis itself, but probably for many financial institutions, some of the more challenging have come out of subsequent crises. LIBOR and Forex in particular have refocused attention on cultural and behavioral issues in financial institutions and reinforced regulatory approaches. It has also led to an increasing use of personal accountability measures, manager in charge systems, where basically an individual, as we first saw in the context of Sarbanes-Oxley in 2002 in the United States, can be held directly responsible for compliance violations. And that has been an effort to change behavior, because after all, if the individual is potentially on the hook, as opposed to just the institution and its shareholders and insurers paying, it changes the dynamic of behavior and arguably changes culture. And of course, most recently, and perhaps with some of the biggest impacts going forward, Australia. Australia, I think, is very interesting because after 2008, apologies to all of the Australians in the room, Australia often made a big point about how well they had done in the global financial crisis. And that's true, they did. And one of the factors that was always credited for that was the strength of their regulatory system. And many things are very impressive about the Australian regulatory system. But in recent years, just problem after problem has come out, resulting in the establishment of a royal commission which reviewed basically behavior across all aspects of the financial system, has resulted very recently in the production of a new report which is very heavily focused on internal cultural and behavioral issues, and which, from the regulatory standpoint, is directing a much stronger focus on enforcement, personal accountability, and cultural change within not only the industry, but also the regulators themselves. And I think lots of regulators around the world, including here in Hong Kong, will be watching the progress of the implementation of those changes very closely. So, that's not everything, but those are some of the more significant evolutionary aspects that really took us from very small legal and compliance departments to very large compliance departments and quite large legal departments in most financial institutions. If we look at legal and compliance today, often legal is separated. Legal is increasingly run quite differently from much of compliance because the demands are often different. Compliance tends to bring together AML, CFT, regulation, HR, a range of other things, and one very important new trend that I'm going to come to in just a minute, and that is data. And I think Cathay Pacific's experience over the past several months has highlighted for many of us, often in a quite personal way, challenges around data, and from the standpoint of Cathay Pacific, the necessity of building compliance functions to better deal with some of those issues. So, if we look at today's environment, what have we seen? For the past 10 years, an explosion in new regulation. The industry invariably says anytime a new regulation comes out, what do you need? You need time to build IT systems to implement that new regulation. Technology has developed over the past 10 years jointly with regulation. That has been made possible by a long time process of digitization of financial services. This began most rapidly in the context of equity markets, but now has expanded pretty much to every major aspect of developed markets. But if we look at China, China has seen the world's most rapid and complete digital financial transformation in a period of less than 10 years. Basically, China's entire financial system is digitized. An increasing range of developing countries are going the same way. Digitization and technology sets the stage for the process of datafication, use of analytics in the context of analyzing that data. And that sets the stage for RegTech. RegTech is the idea of using technology not just for compliance functions, but also from the standpoint of the regulator to achieve better regulatory outcomes. So I think from this idea of digitization, datafication, it's important to highlight it across 4 trends. One trend, long-term digital transformation of traditional financial services. I think this is very clear to anyone working in global markets. The second has been an explosion of new startups. And this has been very exciting, but that's not necessarily even new. 20 years ago, PayPal was an exciting new fintech startup. Today, it's one of the world's payment majors. But amongst those startups, one of the most fertile areas has been RegTech. Why? Because of the massive increases in compliance spending by financial services institutions have opened up a range of opportunities for new entrants as well as established providers in providing related services. The third piece is really about developing countries. And not only China, but an increasing range of developing countries with India, Russia, and others serving as very high-profile examples are experiencing similar processes of digital transformation. The final trend is one that we've seen in 2 directions, and I think it's one that will highlight many of the issues that we're going to look at next, and that is what we call TechFin. TechFin is tech firms entering into financial services. And it's very different because many tech firms have out at the core of their business models which are based on having few staff. And so if you look at something like Ant Financial or Amazon in the United States, the effort very much is to, from the very beginning, whenever faced with a compliance requirement, to automate that. But in many cases, that actually requires them working very carefully with the regulator, because it's one thing for the financial institution to automate delivery of reporting or other compliance aspects, but it's another for the regulator to actually have systems that can accept those digitized reports. And certainly one of the best examples of this took place in the context of mainland China, in between the central bank and Alibaba in the context of Alipay. Central bank needed information about the payments being made through Alipay. Why? Because there are more payments taking place through Alipay than through the traditional financial services sector. So from the standpoint of the central bank seeking to monitor and influence the macroeconomy, they need information about the payment system. Alibaba says, no problem. We can provide you a raw data stream of all of the billions and billions of payments that are taking place. And the central bank says, whoa, what are we going to do with that? And so eventually you have a process where the two work together, where you end up an automated flow of data from the regulated institution, Ant Financial now, to the regulator, which has now developed its own digitized systems which enable it to accept and analyze that data stream. So the challenge here is really about scope and scale. Things move fast. And what we're seeing everywhere is an increasing use of technology, the idea of RegTech. And I think when we write about RegTech, we think of it not just about compliance, but also about how regulators use technology, and in fact, how you can go about designing better systems. And I'll come to both of those. Let's take the example of financial institutions and the industry. I think my favorite example that highlights this more than anything else, because we're in the Bank of America building. 2 years ago, Merrill Lynch, part of Bank of America, was fined just over £43 million by the UK FCA for failing to report just over 72 million exchange-traded futures transactions. 72 million exchange-traded futures transactions over a 2-year period. 2-year period, looking at the opening hours of the futures exchange in the UK, that breaks down to roughly 1,500 exchange-traded transactions every minute of every opening business hour for the 2-year period. What is that? That's high-frequency trading. There's not some guy who is hitting the button as fast as he can. That is automation. Now, if you are the compliance staff at Merrill Lynch, how do you deal with this? Do you have someone who's sitting at the end of the table that is constantly, every time a trade takes place, a piece of paper is getting spit out, and they're having to write a report which is then submitted? No, impossible. The only way that you can deal with that is to automate the compliance function, to automate the delivery of those reports. And of course, from the standpoint of the FCA, what are they going to do with reports about 72 million exchange-traded futures transactions? They have had themselves to build digitized systems to receive reports. All of this has very much been driven by new post-crisis regulatory requirements in the EU, particularly in the context of MiFID and MiFID II. If we look at regulators, I mentioned the SFC is in the process of building an SEC-style Edgar system. ESMA in the EU, as part of the run-up to MiFID II in particular, has had to build similar sorts of systems. But actually, technology for securities enforcement by regulators has a long history. Certainly since the late 1980s, the major tool for the US SEC to trigger insider dealing investigations is monitoring the trading tape. all you have to do, because the majority of insider trading occurs around a major corporate event. So merger is announced between two corporates on X date, X time. You then take 6 months of trading data. You look for any trading that takes place between the already reported list of insiders, which is available to the exchange and the commission. If you see that an insider or a family member has undertaken an unusual trade at a certain time in advance, that will trigger an investigation. At the least, it will trigger an inquiry from the SEC to the financial institution about this particular type of behavior. One of the best examples of this in recent years came from another issue that we're going to come to in just a minute, and that is the hack of one of the largest banking data providers, Equifax, and the discovery that several of members of its senior management, including its chief financial officer, had traded in the period between discovering the hack and notifying it. How do you discover that? Simple monitoring of trading data. And this is something that I think we're seeing everywhere in the world. So regulators using technology is not necessarily a new idea, and it's certainly something that if we look, and I'll come back to some of the regulators in just a minute. If we look at EU, I think one of the big drivers have been MiFID II, GDPR, most recently PSD2. And these together have really had an explosive effect on the process of digitizing regulatory reporting across not only finance, but also data, because data has to be stored in a certain way, and particularly under GDPR and PSD2, that data of individual customers has to be portable. And I think from the standpoint of the EU, we're at a point where it has become very obvious that technology and the way that you apply technology to both compliance functions as well as regulatory functions is key. And that really highlights an idea. That is that as we go forward, there's really a necessity for regulators to work closely with the financial services industry in designing systems. Many of us have seen how this can go badly wrong when systems are not designed well from the outset. The best example, OTC derivatives reporting. OTC derivatives reporting, an area where everyone agreed at the G20 and most of the world, in fact, that it was a pretty good idea. But individual regulators left to then create their own reporting templates and details have meant an absolute nightmare from the standpoint of cross-border financial institutions dealing with reporting requirements in multiple jurisdictions. They've also made the data being collected from multiple regulators largely useless on an aggregate basis. Why? Because the data being collected in each jurisdiction is being reported in different ways on different timescales, and as a result, if you seek to aggregate it across multiple jurisdictions, it's not comparable. And as a result, you have no better information about the sort of Lehman interconnections in the derivatives markets than you did prior to 2008. So, I think if we look at the EU, it shows an example of a jurisdiction looking at systems design. But it has to be said that the divisions of the European Commission that designed the post-crisis financial reforms, CRR, the Credit Reporting Requirements Directive, MiFID II, the Markets in Financial Instruments Directive, those who designed the data protection framework for GDPR, and those who designed the payment services framework, when they were designing their frameworks, they didn't talk to one another. Each division came up with its own system, which internally makes a great deal of sense. But when you, as a financial institution or otherwise, are faced with the challenge of dealing with the three sets of requirements across the financial regulatory requirements, GDPR, and particularly the open banking requirements of PSD2, it's often impossible. And that is something that I think from a compliance standpoint highlights that as we proceed with digitization, we've got to think a lot more about systems design. Where are we with RegTech and major regulators? I've highlighted the SEC. FINRA in the United States has a very long history of this. FINRA estimates that they have 100% real-time data on every equities transaction in US markets. They also have a massive data set of historical enforcement actions, which allows them not only to use traditional data analytics, but also a range of big data non-traditional analytics, which they use in monitoring the behavior of the industry in the US. And I think FINRA has been developing this since the 1980s, and we're seeing an increasing range of regulators following this. CFTC, several months ago, announced the intention to transform their entire system towards a much more digitized system that was more efficient and more effective. Federal Reserve, slower, but collecting lots and lots of data and increasingly thinking about analytics. UK, FCA has been a leader. Bank of England very much has been an early mover. In the context of the EU, ECB, particularly in the context of macroprudential, ESMA in dealing with MiFID and MiFID II reporting requirements, but probably one of the big leaders has been the MAS in Singapore. MAS in Singapore building their own internal cloud, putting together systems of digitizing all reporting requirements, which then allows use of analytics, including various forms of natural language AI, across those reports, even experimenting, according to press reports, with live granular data streams from one of their largest financial institutions. So I think when we're looking at Singapore, a very interesting example. But of course, the big difference between the MAS and the regulatory system in Hong Kong is that the MAS is a single regulator. It operates across the entire industry. Certainly, the SFC has announced and has tendered for a series of initiatives. The HKMA likewise has announced and tendered for a series of initiatives. Certainly, in the context of the HKMA in particular, the launch of the first set of virtual banking licenses basically requires heavy application of technology. Why? Even though the virtual banks in Hong Kong will not be entirely virtual, they have to have an office that regulators can still go visit. They will be largely virtual. And what that means is that the regulators have to have systems and tools to deal with entities that are in many ways very different from the traditional banking institutions that they've dealt with historically. And so SFC, HKMA, HKX certainly in a process of, in the IPO system, changing systems. So regulators definitely moving in this direction as well. Looking around the world, and I'm just going to wrap up with a couple of quick points. I think the first is what sorts of lessons are we seeing from around the world? And this is a big paper that we did from the FSDC last year looking at these issues in Hong Kong. We're seeing the greatest effectiveness in jurisdictions which have eKYC systems based around digital identification systems. These then combined with open access electronic payment systems. And certainly if we think of Hong Kong, this is one area where Hong Kong has very much been a world leader. This is the only place in the world that you can make payments from WeChat Pay to Alipay. Why? A mandatory switch in the payment and licensing system that mandates that. And this is a direction that we're seeing everywhere. Increasingly, a use by governments of this sort of infrastructure to make transfer payments. in particular paying salaries, but also tax payments, pension payments, health payments, any sort of payment, you should be able to do this digitally into an identified account for most populations. And this is a direction that we're seeing an increasing range of countries move. All of these features are seeing a transformation in financial access. And often from this area of financial access, it's highlighted that 1.7 billion people around the world still lack access to a financial account. But for me, what's really as exciting is over the past 8 years, 1.3 billion people have gotten access to a financial account for the first time. Not in Hong Kong, it's too difficult to open a bank account. But in other places, we have seen an absolute explosion in new accounts, new participation. So, looking forward, I think from the standpoint of compliance issues, compliance departments, the first theme that you should take away from today is the scope of regulation continues to increase. If anything, one of the biggest challenges is an increasing fragmentation between different jurisdictions. The long-term trend of harmonization may be breaking down. Fragmentation, if anything, requires greater use of technology in terms of being able to build systems that can take the same data set and produce it and deliver it to multiple regulators as required in different ways. So increasing numbers, fragmentation, but also still lots of agreement at the international level on directions around corruption, taxation, financial regulation, AML, and the like. All of this drives, I think, something that we're already seeing in an increasing range of financial institutions, but also corporates. And that is that a new portfolio is being or will soon be added to compliance. And that is about cybersecurity and data protection. Why? Because some of the fines available, particularly under the GDPR framework, are very, very substantial. Likewise, in an increasing range of jurisdictions, including Hong Kong, there are issues around this that are driving public attention. And so, from the standpoint of a financial institution, compliance functions will have to deal with data protection requirements. They'll also have to deal with the interaction of those data protection requirements with securities and financial regulatory issues. When do you disclose and to whom do you disclose? And in particular, once you've discovered a breach, how do you manage it? Because most of dealing with a breach is not finding it. It's about getting them out of the system, figuring out what sorts of damage has been done, and dealing with the fallout. So cybersecurity risks, data security and protection risks. I would add an interesting one. Technological risks. And I think we can think of this in particular from two different directions. The first is an increasing reliance on data providers. In other words, for most of the financial services industry, there's a very heavy level of reliance on streams of data from certain providers, and questions about the risks of that and how that should be dealt with. The second is around new technologies. And obviously we can think about things like blockchain or AI, but I think probably the one that is going to get some of the biggest attention are cloud services. Cloud services because fundamentally you are changing the existence of your business. For a startup today will not go build a server room. They will hire cloud space with Alibaba or Microsoft or Amazon. And increasingly for larger firms, there is a process of transforming their operations as they move almost all of their functions onto cloud-based platforms. I think a big announcement is coming soon, and that is the US Department of Defense is tendering for a cloud provider. The US Department of Defense is moving most of its operations onto a cloud-based platform. that largely says that probably everyone else who has not yet done it will be moving in this direction soon. But it brings with it both good news and bad news. The good news, in my view, is that for just about every firm that is not a very large firm, in other words, if you are a global bank, you can probably afford the people, the technology, the designers to build a system that will be as good as you can get from a major cloud provider. But if you're anyone outside of that top scale range, what you get from Amazon or Microsoft or Alibaba will be better from a standpoint of security, data safety, data location, analytics, than you will be able to build yourself. And that is a very important consideration as compliance departments become increasingly responsible, not only for traditional things like finance, corruption, taxation, AML, but also from the standpoint of data protection, data security. It's a quick pitch. If you want more about this, we have a free online course on EDX. I've probably gone on just a little bit longer than I anticipated, but I wanted to thank you all for your attention, thank Chinese U for the invitation,